Good morning everyone, this is Attorney Lay. Today we are going to discuss all about grounds for annulment of marriage. So what are the grounds for annulment of marriage? Article 45 of Family Code provides for 6 grounds of annulment of marriage. The first ground, that the party in whose behalf it is sought to have marriage annulled was 18 years of age or over but below 21, and the marriage was solemnized without the consent of the parents, guardian, or person having substitute parental authority over the party, in that order, unless, after attaining the age of 21, such party freely cohabited with the other and both lived together as husband and wife. The situation here is that the contracting parties enters into a marriage at the age of 18 years old and above but below 21 without parental consent. In such a case, your parent or your guardian can file a petition for annulment of your marriage at any time before you reach 21 years old. On the other hand, you can file petition for annulment of your marriage in court within 5 years after attaining the age of 21. It is also important to remember that if the party concerned reaches 21 years of age and you freely cohabited with the other, and both of you live together as husband and wife, then you can no longer file a petition for annulment of your marriage in court. The second ground, that either party was of unsound mind, unless such party, after coming to reason, freely cohabited with the other as husband and wife. Unsound mind, meaning insanity. One of the contracting party at the time of marriage is incapable of understanding the nature of the act, or either party was mentally incapable of giving free and intelligent consent to the marriage. Now, who can file this petition for annulment of marriage? First is by the sane spouse without knowledge of insanity. It can be filed at any time before death of either party. The second is by the relative, guardian, or person having legal charge of insane. It could be filed also at any time before death of either party. With respect to insane spouse, the petition for annulment of marriage can be filed during lucid interval or after regaining sanity. The third ground is that the consent of either party was obtained by fraud, unless such party afterwards, with full knowledge of the facts constituting fraud, freely cohabited with the other as husband and wife. Fraud refers to non-disclosure or concealment of certain circumstances which materially affect the essence of marriage. So what are these fraud? Okay, example is that non-disclosure of previous conviction by final judgment of a crime involving moral turpitude. Second is the concealment by the wife of the fact that at the time of the marriage she was pregnant by a man other than her husband. Third is the concealment of sexually transmissible disease regardless of its nature existing at the time of marriage. And fourth is the concealment of drug addiction, habitual alcoholism, or homosexuality or lesbianism existing at the time of marriage. Please also take note that you can file this petition for annulment of marriage if your ground is fraud within 5 years after discovery of fraud. The fourth ground is that the consent of either party was obtained by force, intimidation, or undue influence, unless the same having disappeared or ceased, such party thereafter freely cohabited with the other as husband and wife. It only means that there was a vitiated consent at the time of celebration of your marriage. The consent, which is one of the essential requisites of marriage, was not freely given but was obtained through force, intimidation, or undue influence. An example of this is when a person coerces you or threatens you or even forces you to enter into marriage. That would constitute as a ground for annulment of your marriage. And in such a case, you should file a petition for annulment of your marriage within 5 years from the time force, intimidation, or undue influence disappeared or ceased. The fifth ground is that either party was physically incapable of consummating the marriage with the other, and such incapacity continues and appears to be incurable. What is important here is that there must be a physical incapability and permanent inability on the part of one of the spouses to perform complete sexual intercourse. So, non-consummation of marriage may be on the part of husband or wife and may be caused by physical, or it could be due to chronic illness. So, mere refusal of party without being physically incapable to engage in sexual intercourse do not by itself and will not constitute as a ground for annulment of your marriage. So when can you file this petition for annulment of marriage if your ground is incapability to consummate marriage? So the time or prescriptive period, it should be filed within 5 years after the marriage ceremony. The last ground is that either party was afflicted with sexually transmissible disease found to be serious and appears to be incurable. The important thing to remember here is that the sexually transmissible disease should be serious and incurable, and the prescriptive period within which to file this petition for annulment on the ground of sexually transmissible disease is within 5 years after marriage. Thank you very much for watching my video, and once again, I hope you will join me in my next video. The topic would be declaration of nullity of marriage, and I hope that you will like, comment, and subscribe to my channel. Thank you. Bye.